In this case, the prosecution was persecuting, not prosecuting, they were persecuting. So the CCT is a neutral court.
What role, I mean, what interest does the prosecution have in this, if not working for the CCB?
No. CCB and CCT may be created by the same law, but they are distinct in their performances.
I realize that.
Good. They are distinct. So CCB does investigation and others, but they don't tell CCT what to do. The tribunal is independent. They don't investigate. They don't try. What they do is they hear the case and give verdict.
If you dismiss the work of the CCB that they couldn't prove, I mean,
the CCB didn't do any work. Apparently, they didn't do any work because they were reliant on EFCC's evidence and other people.
So if that is the situation, we can't say that there was anything political in this?
That is the very reason why we will even say it is political, because as an institution, the CCB is supposed to stand their ground. They know the right thing. They are supposed to say, look, this man have declared his shares in these companies. This man have declared this. There is no column for declaration of MasterCard in our form. We cannot go to court and make a fool of ourselves.
But it's an offense.
Well,
it is an offense.
Until the law says it is an offense.
For public officials to operate and own accounts abroad.
Was it part of the charge?
I'm simply asking you, is it an offense
in our laws? If it is prohibited, then you need to show it. And you need to show the law that prohibits it.
Are you saying that as a legal practitioner, you're not aware that public officials are not allowed to operate foreign accounts?
When in office. Because you're not a public official all your life.
So right? it's a good thing that you say when in office.
Yes.
The question is, the Senate President, we do know, has been in office since perhaps 2007, thereabouts, when he was governor, and then he went to the Senate, and he's been there for a long time. And
before he got to the Senate, Mr. Whitcas, or what's his name, one of the witnesses, was asked, as at 2003, was Saraki worth $23 million or not? He said yes, he was worth $23 million. Mr. Samuel also agreed with that. So, and they said, if this man was worth $23 million as of 2003, do you think that 10% of his investments can pay off so loan? They said yes. So what are they saying? You need to work harder than what these people have done. If you want to catch a thief, they say you don't hold him by the elbow, right? You do know that people are not very confident in terms of what happens in Nigerian courts. I mean, and they look at situations like this, they look at cases like this, and they say, we do not think that we have the desired confidence that we should have in this court. What do you think can be done to put back that confidence? I think no judge will want to put his folly on the paper. No judge will want to do that, to come and write a judgment with which you can nail him or her. No judge. You must understand that the theater of litigation, the judge is not the only actor. There is a prosecution and defense counsel. There are witnesses. You must tie all of these things together. So if you're a prosecuting counsel, you must prepare, knowing that the burden is on you and it never shifts. It never shifts. The defense can just sit and watch you kill your case or make your case. If you want the defense to work, you need to work harder. The defense will be looking for holes. The judge himself was a lawyer, so both lawyers can do what the judge is doing. So the judge knows that both parties are watching him or her. So they are careful. Now, if you want to solve this problem, get better prosecuting teams. Get better prosecuting teams. When you put a good prosecution and the judge does anyhow, you can call his attention to it. You can petition the judge. But you don't do a case. You said it should get better prosecution teams, and in this instance, the court of law is saying that teams are not known to law. No. Teams are to work for themselves, not to come to court and say, I was given this evidence by a team. No, that is your business. You're working as a team. But when you come here, the law expects you to present the evidence of what you know, what you saw, perceived, or heard, not what the team saw, perceived, or heard. The team is not a person. It's not a legal personality. Is it an incorporated team? Which team? Is it CCB, EFCC, or DSS team? It's not a person. It's not known to law. But your team can work to present one person who saw, heard, or perceived, to represent them there.
So are you insinuating then that this perhaps was a shoddy prosecution?
It's beneath shoddy even. That is how I'll put it. Beneath.
Because perhaps this is not because there was no case really, but because the prosecution did not do a good job.
There is no case even in this case. There is no case because if there was a case, at least we would have moved to the level of real defense.
Why then do you think? I mean,
there was no defense in this case.
If really in all of this there was no case, why do you think that the defense tried their best to ensure that the court did not even sit in the first instance?
Because they knew something we did not know, including the defendant himself. They knew what we didn't know, and they've been saying it all along, that this is a political witch hunt. There is nothing, because they've seen the processes that we didn't see, and they've seen that there was nothing to sustain the charges.
So if there was nothing, why didn't we get here? We could have gotten here quicker.
Because the prosecution was out to win a media war. They were out to win a media war, and they probably succeeded to an extent.
What we're saying is this. Initially, there were complaints about the fact that there were only 2 people on the panel instead of 3, and they were incomplete. There was question of jurisdiction and all of that. And then the case got up all the way to the Supreme Court.
Yeah.
The Supreme Court said, you have a case to answer. Go and face your trial. The tribunal, as it's constituted, is competent.
Yeah.
Now, if that were the case, if there was really nothing to it, if there was no merit to it, why did we have to get up all the way to the Supreme Court?
Now, I tell you something. When God wants to help you protect your good name, He uses your enemies sometimes. And as human beings, we fear what we don't know or understand. The defendant do not know what these men have in their arsenal, so they needed to fight. But while they were fighting, they were making this judgment even stronger, because if the Supreme Court had not said the CCT had jurisdiction, we would be saying whether the CCT has...
We will let you finish your thoughts in just a moment. Let's take a moment and we'll be right back. Just stay with us. Well, Mr. Silas Onu is a legal practitioner. He's still with us in the studio. Just before we went on break, you were talking about why it was that the defense, had to get up all the way to the Supreme Court before coming back down to the CCT for trial to commence.
Yeah, I said the importance of that was that we had the Supreme Court in the process pronounce that the CCT has jurisdiction to hear and determine that case. So it now gives more weight to this judgment, clearly showing that the CCT has the power to discharge and acquit him. If the Supreme Court had not made that statement, by this morning you'll be hearing or reading in the paper that CCT has no jurisdiction, but thank God that all of these issues were settled. Even if it was not in the CCT Act, the Supreme Court had pronounced on it, so it becomes law. They have that power.